Officially started. Welcome everyone to the Kinder Institute's Friday Colloquium series. As we get started, I'll just remind everyone to make sure that their microphone is muted. If it's not and it's disturbing, I will mute you. I am Connor Ewing, a Kinder Institute Assistant Professor of Constitutional Democracy and Assistant Professor of Political Science here at Mizzou. I'm new to both the Kinder Institute and to Mizzou, but even in the couple months that I've been here, I've come to see that this Colloquium series is both reflecting and furthering the Institute's core commitment to cultivating a community of thought and scholarship that is oriented around fundamental questions about American political thought, history, and institutions. Most of the names and avatars I see here are familiar, so I think most of you already know that, but welcome. And welcome to our guest and speaker today, who is Christina Bambrick. Dr. Bambrick is Assistant Professor of Political Science at the University of Notre Dame. She arrived there this year after teaching at Clemson University. She is a scholar of constitutional theory and development. Her research and teaching interests range from American and comparative constitutionalism to Republican theory and the history of political thought. She is currently writing a book on the horizontal application of rights to non-state actors in comparative context, which I believe we will hear more about this afternoon. I want to flag two of her publications, both of which are recent, that may be of particular interest to those here. The first is Horizontal Rights, a Republican Vein in Liberal Constitutionalism, which was published just a few months ago, though it feels like years ago, I think in July of 2020 in Polity. If you like what you hear today, I encourage you to go chase down that article. It's excellent. And another one that speaks to the diversity of her scholarship and her interests is Neither Precisely National Nor Precisely Federal, Governmental and Administrative Authority in Tocqueville's Democracy in America, which is a fantastic meditation and kind of excavation of Tocqueville's thinking on the American regime that was published in Publius in 2012. Sorry, 2018. 2012 was way too long ago. Dr. Bambrick's talk today is titled, Who's Responsible for Constitutional Rights? I look forward to a long and hopefully vigorous Q&A after the talk. I'll mention this again at the end, but if you'd like to get in the queue to ask a question, just drop a message into the chat and I'll keep track of that. You can also write your message there if you're more comfortable with that. Before I hand things off, as a note of personal privilege, I'll say that while it's always a joy to welcome guests to campus, even if it has to be virtual, it's a special opportunity and honor to welcome someone who I consider a friend. Christina and I went to grad school together at the University of Texas, and her presence there not only enriched the intellectual environment and contributed greatly to my own development, but it made grad school, believe it or not, fun, even a deeply humane experience. So it's a special honor to welcome Christina Bambrick here to the Kinder Institute. I'll hand it off to you, and I will hopefully not struggle to share my screen and get your slides up.
Great. Well, thank you so much for that very kind introduction, Connor. I'm really glad to be here. Thanks for inviting me, Justin, and I look forward hopefully to visiting Columbia again when it may be possible. So let me get things in order on my side too. And with that, I'll begin my talk with just a couple of questions. So how far do your constitutional rights extend? Put differently, who is responsible for protecting and promoting your rights? A 1999 case decided by the US Supreme Court begins to answer this question. A small child by the name of Joshua Duchene suffered serious abuse at the hands of his father. Wisconsin Social Services reported to the resident several times on suspicions of abuse, but did nothing to remove him permanently from his father's custody. The abuse continued until he suffered irreversible brain damage with which he would live for the rest of his life. When the mother, who lived in a different state, learned what happened, she sought retribution on Joshua's behalf. The father was charged and convicted of child abuse, but the mother argued the state was also culpable in that social workers knew about the situation and did nothing to protect Joshua's positive right to liberty under the 14th Amendment. So the case went to the Supreme Court, who decided that the 14th Amendment did nothing to establish an affirmative duty of the state to protect against private abuse. Because Joshua's injuries were inflicted by a private party, the Constitution did not offer any rights protections. The only remedy came in the father's conviction of child abuse. This decision is based on an idea known as the state action doctrine, the idea that only state action is accountable to constitutional rights obligations. Put differently, the idea is that the Constitution creates a vertical relationship in which the state is accountable to the people's constitutional rights. So in other words, rights are triggered only when the state has inflicted some harm, not when a private actor has inflicted a harm. This may seem unintuitive to non-lawyers. Why shouldn't one be able to invoke constitutional rights in private spaces? After all, Marianne Glendon reminds us that Americans love rights talk, so why not here? The rationale for this vertical model is that by preserving private actors from constitutional obligations, we permit a separate private sphere in which these actors may enjoy greater liberty and pursue projects and commitments of their own volition. So while the Duchene case is notably sad, in general, this vertical model is supposed to act as a sort of buffer between the projects to which the state commits and private actors' ability to pursue their own commitments. For example, you might consider some of the issues that people often refer to as the culture war, maybe abortion, for example. This issue area has now a right attached to it. Given the controversy surrounding this particular policy area, though, one must ask whether we would want this rights language to be brought into private spheres, regardless of what one thinks about this policy area in general. Just as a prudential question, you can ask whether it makes sense to have private actors enlisted in this project. So maybe the way it might affect private hospitals, for example. So let's advance to the next slide, if you don't mind, Connor. So in contrast with the traditional vertical understanding of constitutional rights, some countries have increasingly adopted a horizontal model in which private actors are also responsible for one another's rights. This means businesses, private hospitals, private schools, even private individuals become responsible for rights ranging from equality to freedom of speech, and even positive rights such as the right to health, depending on the country in which we're talking about. So to take an example from my research, in 2017, the South African Constitutional Court decided that landlords had a positive obligation to ensure that their tenants lived in conditions consonant with human dignity. This was not about housing regulations or building codes. This was about the constitutional right to dignity. So if the purpose of maintaining this vertical model is to protect a sphere of liberty, you can probably guess that the goal of this new horizontal model and of introducing rights language into private spaces is to address as a constitutional matter abuses wherever they may exist, harms wherever they may occur. And as we know, harms often do occur in private spaces. So when seen in contrast with the Duchene case that I began with, this horizontal model may seem like an obviously great innovation, perhaps even worth yielding some of the traditional protections to which we often give to private spaces. But the horizontal model also comes with potential trade-offs. Again, one might think of these very divisive issues that I mentioned already, such as abortion, to which we attach the language of rights. More remote examples, but ones that are worth mentioning, are instances in which horizontal effect hasn't necessarily been used to achieve justice, but actually has been employed toward nefarious ends. So for example, the earliest implementation of horizontal effect, this horizontal model in Germany, in the German labor courts, came as a holdover from Nazi labor law, which privileged public policy and collective ends over private ends, private rights, private interests. Something like the horizontal model, horizontal effect, also appears in the Soviet Constitution. So this isn't to say that contemporary instantiations of this go so far as that, but only to show that as a historical matter, something like this has been employed toward totalitarian ends. An example that perhaps is a little bit easier to recognize or imagine in our current landscape, the 1966 Constitution of Lesotho employed horizontal effect, in part to protect rights, but in part also as an effort of certain partisans to maintain a foothold in private spaces. So in other words, to manage private entities that didn't always act in the best interest of these particular partisans. So trade-offs in both instances. The big question, therefore, is which model is preferable? This is the question which my talk addresses, and I'm sorry to say that it's the question to which I will offer something of a non-answer. The short of it is, as I've already said, there are potential trade-offs in adopting either model. There are reasons for adopting each and reasons not to. And so in addressing these questions of public and private, of state and non-state actors' obligations, each model operates on a different logic and with different presuppositions. So I argue that this decision is and ought to be very context specific, respecting the particular issues and goals of a polity. I therefore aim for a very modest goal in this talk, which is basically just to offer greater clarity about the choices at hand, highlighting the different operative logics and the presuppositions of each model, and then seeing how they actually function in practice in a couple of different countries. So if we want to advance to the next slide, Connor, that'd be great. So I'll proceed as follows. The first part of this talk will briefly sketch out these different ways of thinking about the reach of constitutional rights. I've already done that a bit just in my introduction, so I won't dwell too much on this, but just highlighting the fact that these models do entail different logics, different presuppositions, as I've said. And the second part of my talk, which will be the bulk of it, is to show how theory meets practice, to show how these logics and presuppositions of these different models in the abstract actually come to bear in particular issue areas in actual places. So horizontal effect may make sense in certain countries or even in specific issue areas of certain countries, whereas in other places, we might find compelling reasons still to rely on the traditional vertical understanding of constitutional rights. For my cases, I will draw primarily from the United States and South Africa, largely considered paradigms for the vertical model and the horizontal model, respectively. I'll consider the debates in which each adopted these respective models, as well as the constitutional politics of subsequent developments. So I'll begin by recapping the basic logic of these models, which I've already gone over a bit. First, all governments are in the business of regulating private actors. It's worth highlighting and clarifying. Even the most libertarian governments are in this business. So going back to Hobbes and Locke, the point of government was actually to protect people from each other. So the practical question then becomes, how do we want to handle this function of government to regulate private spaces? And if you could advance to the next slide. The traditional answer has been the vertical model. So the relationship between state and the individuals that constitutions traditionally are thought to establish. So on this understanding, the state is bound to protect and promote the rights of individuals, the rights of citizens. On this model, public and private spheres are regulated by different kinds of law. Insofar as the Constitution only obligates public actors, state actors, you therefore are left with the separate private sphere, which is regulated according to private law. And as I already mentioned, the idea behind this model, the rationale, is to protect liberty in this separate private sphere. People are able, therefore, to act separately from this same constitutional standard, or at least not directly under it. This is the default understanding of in constitutions, even today. But one innovation we've begun to see more and more is this idea that rights might apply horizontally. And on this horizontal model, rights relationships exist between private entities. So now private actors are bound to protect and promote each other's rights. As I said, this refers to private individuals, but also businesses, hospitals, private schools. And on this understanding, the big difference is that the Constitution now regulates both public and private spaces alike. Everyone is potentially accountable to constitutional rights. And if the vertical model, if the end of the vertical model was to protect a separate sphere of liberty in which people might act, the objective, the rationale behind this more recent horizontal model is typically a more egalitarian concern to protect rights in all spheres and to remedy harms wherever they may occur as a constitutional matter. All right, next slide, Connor, please. So this is kind of a digression, but as a point of interest, I thought I would mention the objective of my larger research project. The vertical model is typically understood through the light of classical liberalism, the classical liberal understanding of rights, the distinction between public and private spaces. What I bring to this discussion in my larger book project is to understand this new horizontal model as having a more Republican logic, that it can be understood not necessarily historically, but theoretically in terms of civic republicanism, the way it brings duties to the conversation, et cetera. So I won't dwell on this, but I thought I'd mention it in case anyone wanted to discuss it in the Q&A. Next slide, please, Connor. Okay, so I've been talking about the logic of the vertical model, the presuppositions that these different models have. What exactly do I mean? Speaking first of the vertical model. It frames questions in terms of a divide between public and private. This may seem obvious in light of everything I've already said, but I want to really take a moment here to reflect on what this is and means. Basically, it presupposes that there even are separate public and private spheres of which to speak, that these categories are meaningful and worth maintaining, even if it is a messy business drawing the line. And in fact, this is the task that the vertical model creates for judges. It's to draw the line between public and private and allocate constitutional duties accordingly. So insofar as this is a public state actor, we know that these actors have constitutional rights. Insofar as these are private non-state actors, they do not have the same obligations, constitutional duties, and don't have constitutional duties. So again, this is a messy business. Any person, any lawyer who will tell you about the state action doctrine in the United States knows that this is a messy business. But the point of this model is that these categories serve a purpose and are worth preserving. So what then of the logic of the horizontal model? If you want to advance the slide, Connor, I might forget to tell you. Thank you. So this horizontal model instead structures understandings of public and private as perhaps different. It doesn't always collapse them necessarily, but no longer are they entirely separate either. So now we see a sense of shared duties across public and private spheres. The very questions that we begin to ask under the horizontal model are different insofar as they presuppose we can speak of constitutional duties in private spaces. This isn't a line drawing project as much as it is a weighing project. The task of courts now is to weigh rights and duties against each other insofar as citizens and private entities in general do have constitutional duties. The next slide, please. Okay, so all that by way of introduction, thinking about that from an abstract bird's eye perspective. How then does theory meet practice? How do we see these models operating in real places, in real cases? And I'll begin with the vertical model. The doctrine is known as the state action doctrine in the United States. Next slide, please. So before I jump into it, let me just say it's impossible to discuss the vertical model in the United States without also discussing the history of race and slavery in America. So in a way, drawing on the US case as a model for discussing the vertical model may seem to stack the deck against the vertical model. It's certainly tainted by this history. What I'm going to try to show is that there were certain key moments where Congress or the courts might have adopted a qualified horizontal model in the United States context to address these particular issues of inequality and discrimination, while still maintaining something of the traditional vertical model in general. So as you probably remember, the United States explicitly committed to equality for the first time in its constitution with the Reconstruction Amendments. You have the 13th Amendment abolishing slavery, the 14th Amendment guaranteeing the rights and, the privileges and immunities of citizens, due process of law, and equal protection of the law, and the 15th Amendment guaranteeing the equal right of all men to vote. Next slide, please. So from the outset, there was debate in Congress about how far these amendments would extend, what, in other words, these amendments would mean for private actors. And I'll focus primarily on the 14th Amendment here. The divide occurred along the lines of the centrist Republicans and the radical Republicans. The centrist Republicans wanted to highlight, emphasize this language in the 14th Amendment, which states, "No state shall make or enforce any law, nor shall any state deprive any person of life, liberty, or property." So in other words, that these amendments were addressed to state actors. And to that extent, the centrist Republicans wanted to cabin the reach of the Reconstruction Amendments only to apply, especially the 14th Amendment, only to apply to state actors. The division they made was between social rights, which they thought the 14th Amendment didn't touch on, and civil rights. So in contrast, the radical Republicans relied on another provision in the 14th Amendment. I don't have it reproduced here, but it's the Section 5 enforcement power, whereby Congress is given the authority to enforce the provisions of the 14th Amendment. So the radical Republicans took this to mean that if they wanted to, they could legislate according to this new commitment to equality, even in private spaces. And that is what they did with the first Civil Rights Act, just after the amendment was adopted. This isn't the same thing as the more famous Civil Rights Act that we talk about more often in 1964, but this actually largely aimed to accomplish the same purpose, basically to bring equality into privately owned places, inns, public conveyances, places of public amusement. So this question came before the Supreme Court, and in a decision authored by Justice Bradley, pictured here, the court rejected this extension of rights into, and especially the right to equal protection in privately owned places, following something like the centrist Republican idea that this simply wasn't how far the amendment was meant to extend. Next slide, please. So out of this case, we get the state action doctrine. It's a complicated history, and I'm having to oversimplify it for the purposes of this talk. Pamela Brandwein has a great history on it, though, that really gets into the weeds. But for our purposes, this was the beginning of the commitment to the vertical model in the United States and to the idea that only state action is accountable to the Constitution. The only clear exception to this is the 13th Amendment, which of course abolishes slavery in public and private spaces alike. Next slide, please. So fast forward, 80 years or so after you have decades of Jim Crow, and this question rears its head again. You have the civil rights movement, you have students sitting in at lunch counters, and so the question becomes, what obligations, if any, do these privately owned institutions have with respect to the Constitution? Now, even the ambitious Warren Court was very hesitant to wade into these doctrinal questions again. There were decades of precedent of the state action doctrine, and so they really didn't want to revisit the constitutional question, and instead would largely dismiss cases on technicalities, almost always in favor of the protesters, but never really getting to the question itself. One exception was Justice Douglas, who was willing to go back in time and reassess. And as you see, I have a quote from his concurring opinion in Garner v. Louisiana here, where he says that restaurants, drugstores, department stores, bus terminals should all be accountable to the Constitution in some sense. But look at how he goes about making his argument. Next slide, please, Connor. You'll see he's still arguing in terms of public and private. These are a part of public life, though they are private enterprises, they are public facilities in which the state may not enforce a policy of racial segregation. So even still, we see some, we see the deep roots of the vertical model and how we're still understanding these spaces in terms of public and private. As you probably know, just a short few years after this case was decided, Congress finally passed the Civil Rights Act and passed it on the somewhat awkward basis of Congress's power to regulate commerce. So the suggestion I want to make is that in this particular area of racial equality, it seems that something like a horizontal model in this particular issue area might have served the country well. Maybe following something like Congress's original legislation with the original Civil Rights Act, rather than fast forwarding in time, having to rely on something like commerce. And this is because the issue of race and equality is uniquely important to US history. So this wouldn't necessarily have been a silver bullet. We likely would have had something like Jim Crow emerge anyway, but it would have given more tools in the proverbial legal toolbox by which to combat this. So that's my suggestion here, but let's consider other issue areas. Next slide, please, Connor. Let me make sure we're, okay. So I've tried to come up with a couple of areas that are issues that are both current and that would be compelling to people of different political persuasions in order to think through how, even if the horizontal model might have been useful In the area of race and equality, there are certain issues that we confront today where the vertical model might still be worth preserving, insofar as it allows issues to be framed in ways that acknowledge persisting disagreement. So I'll start first with a case before the Supreme Court this term, Fulton versus City of Philadelphia, in which Catholic Social Services has declined to place children, potential adoptees, with same-sex couples, in contrast with the City of Philadelphia's policies. And so imagine, just hypothetically, if we were operating in a country that did have the horizontal model, how this question might be framed. It might come down to, in this hypothetical, a question of, say, Catholic Social Services' constitutional duty to recognize same-sex marriage. So that would be a potential framing that we would see. And so in this instance, the vertical model gives us a little bit of foothold to recognize certain institutions as still private and somehow different from the state, with potentially different obligations. So another issue area that we're seeing in the headlines is Facebook, Twitter, social media platforms, and the belief among many, it seems, that these platforms are accountable to the Constitution, specifically the constitutional guarantee to the freedom of speech. In fact, as non-state actors, it's not prima facie clear that these entities do have any constitutional obligations. And I want to suggest that, again, this vertical model, this maintaining some meaning of private and public, actually lets us appreciate that these are different sorts of institutions, and maybe it's a good thing that they be allowed to maintain certain community standards. Just to draw out the hypothetical a little more, in US freedom of speech jurisprudence, there isn't necessarily a category of hate speech. We have hate crimes in the United States, but we don't have hate speech in the same way that other countries do. And so by allowing these private entities to maintain their own codes of conduct, their own standards, it allows them to operate on that basis. So again, I'm not necessarily coming down one way or another on these particular issues, but just to show how these categories of private and public could potentially do serve an important purpose even still. One thing I'll mention very quickly is an exception to this vertical model in the United States, and that is called the public function exception. So the idea is that once a private entity begins to carry out a function that is typically associated with the state, with government, then it is possible to bring certain constitutional rights obligations to bear. So I'll leave it at that. You can imagine, just using the example of Facebook and Twitter, that's a kind of public forum. And so maybe if we understand it in that light, we might want to justify holding it accountable to the First Amendment freedom of speech guarantees as well. Okay, so if we want to advance to the next slide, Connor. Let's move to South Africa then. And thinking through the logic of these different models, specifically the horizontal model in the light of South Africa's transformative constitutional project. Next slide, please. So the Constitution of South Africa was indeed a transformative project. After years of apartheid, the various parties finally got together, the ANC, the National Party, to come up with an agreement under which the country could proceed under a system of racial equality. So this system has been described by certain scholars, including Frank Michelman, as post-liberal in character, just for the simple reason that it doesn't take for granted the conventional wisdoms of certain questions. It really is meant to transform the entire country as a whole. So in terms of the application of rights, which is the subject of this talk, how far rights extend, to what entities they apply, the South African Constitution doesn't take for granted the vertical model, but also in terms of the substance of constitutional rights. There's a real emphasis on providing for material goods of citizens, and that is in large part, again, due to the history of inequality in South Africa. Next slide, please. So for those who may not know, the South African Constitution was adopted in a two-stage process. First, the country agreed to an interim constitution, which basically just sought to lay the groundwork, basic substantive commitments to which the country knew it would try to ascertain in the new constitution, but also the procedures for how it would go about securing a final constitution for the people. And so this interim constitution shows some evidence still of certain laissez-faire priors, even if the goal wasn't to take for granted the conventional wisdoms of liberal constitutionalism generally. We do see some of that at this early stage of the interim constitution. Just as an example, there's still some distinction between common law and constitutional law here at this stage. In other words, the common law was understood as being the primary way in which private actors were regulated. And constitutional law, on the other hand, was understood as being primarily about regulating public actors, regulating the state. So this question comes to a head even before the adoption of the final constitution in a famous court case, Duplessis v. de Klerk. And in this case, the majority of the court largely follows what I'm calling here sort of laissez-faire priors, the conventional distinctions between private and public law. But in his dissenting opinion, Justice Kriegler already has an eye to what the broader South African project entails, just how transformative it is. And so he wants to say that these kinds of traditional conventional distinctions simply aren't sustainable in light of South Africa's broader project. Next slide, please. So finally, in 1996, we have the final constitution ratified and certified by the Constitutional Court. And so in this final constitution, we see much more clearly just how ambitious of an agenda of social transformation the South African Constitution entails. And so we also see, as part of this explicit provision for horizontal effect, there's no longer any guesswork to be had by the Constitutional Court, by anyone involved. There's clear commitment to direct horizontal effect. And so this means constitutional provisions now bind private actors, schools, businesses, hospitals, even private individuals. And I've highlighted here a couple of provisions where we find this. The first one, section 8.2, is basically the general provision for horizontal effect. And the other, section 9.4, specifically highlights equality and non-discrimination as requiring horizontal effect, as special for the South African project. Next slide, please. So out of this model, this horizontal model, we see emerge a conception now of citizens' duties. Citizens now have constitutional duties potentially in South Africa. And it also, in line with this transformative agenda of the South African Constitution, it's worth highlighting the importance of socioeconomic rights. So by way of introduction to this case that I'll speak of, it's worth mentioning that the subject of land is of particular salience for South Africa. Going back to colonial times, many people were displaced, and the reverberations of that are felt even today. People are often homeless or without permanent dwellings. And so land, it's called the land issue. It's a problem. So in light of that, consider this case from 2005, Motor Clip, which I should mention from the outside isn't technically a horizontal effect case, but I think you'll see why I mention it as I explain it. So there's a private landowner, a farmer, who begins to see individuals settling on his land, basically squatters coming to dwell on his land. And he asks local authorities to evict them time and again. But they don't. And so Motor Clip, and I should say too, it's not just a few, we're talking tens of thousands of people, I think 40,000 in all, over time settling on this land. And so Motor Clip takes the case to the Constitutional Court eventually, and the court agrees that Motor Clip has a right to his property, that he should be compensated, but at the same time that these people should not be removed from the land. Now you may say that's probably partly a practical consideration. How do you go about moving 40,000 people? And that certainly figures into the court's decision, but you also see the court here invoke values of good neighborliness and shared concern, which is to say that Motorclip is still cooperating with this public project in a way, this public good. And so this case shows a sort of reordering, now holding a right to housing, for example, as a background right, in addition to the right to property. Whereas I don't think you would see that in a traditional vertical framework. And so the reason it's not technically a horizontal case is because it's Motorclip bringing his case against the government who failed to evict these people. But at the same time, again, you see these duties of private actors alongside each other. So it is often mentioned in conversations of the horizontal model too. Next slide, please. All right, and then a few other cases from South Africa. We have a 2011 case, Juma Musjid, in which a private trust was looking to evict a private school that was using its facility. And the court in this case decided that, in fact, the trust had a duty not to interfere with the education of these students. Now, that isn't to say that the trust had a positive duty to provide for the education, but insofar as they had begun to lend out their facility, they now could not interfere with the education of students. Another case, which I've mentioned in my introductory remarks, Daniels v. Scribante, decided in 2017. The court decided that here, a private landlord had a duty to ensure that his tenants lived in decent living conditions. So the tenant in question tried to make modifications to her dwelling, and these were pretty basic modifications. This is an area where there sometimes isn't running water or electricity, but even still, the landlord refused. And so the court said, at the very least, this woman has a right to improve her home, her dwelling place. But really, at the end of the day, the landlord too had a prior responsibility to ensure that there were conditions, decent living conditions. And finally, a very recent case just decided in June of this year, AB v. Pridwin, in which the court decided that a private school had a duty to provide a basic education to students. And so this is insofar as the school was in the business of providing an education, it was obligated to this constitutional duty as well. So next slide, please. And the final slide to sum up. We see here how different constitutional models lead judges to ask completely different questions. And these models directly impact the kinds of conversations we have in constitutional discourse in different countries. So it's worth considering the effects these different approaches may have both as a practical and a symbolic matter in these various countries. The way a country articulates its commitments for a people may, in other words, affect how people respond in kind. So I don't want to be positivistic about this. I think we can come to better and worse answers, not just in the light of particular histories, but also in light of objective understandings of justice and natural law. But in terms of application and enforcement, these issues often require prudence. And it is for this reason that constitution makers and jurists should keep an eye toward their histories and current conditions when deciding which model to imply in their polity. So with that, I'll conclude. I think there's one concluding slide, and yeah, I'm looking forward to questions and answers.
Wonderful. Thank you, Christina. You can all see and hear me as I jump in to do this. I'll remind you again to drop your questions or your desire to ask a question into the chat. I think we have a couple already. I'm going to ask one while I read these questions to see if I can understand them first. And it's just an invitation to, I have a bunch of questions. This is such a fertile, hopefully not futile project. And it's something that you mentioned right at the beginning of your discussion of the US Constitution, the vertical model. And it was, of course, race is important here and racial division. And I wonder to what extent or in what ways that plays out across the different case studies. So this may be an opportunity to bring in, not only South Africa, but India and Germany. And it strikes me that in all those three plus the United States, right, the history of ethnic and racial division and histories of injustice are so salient, but in different ways.
Yes.
So Germany, South Africa, India all confront it more or less directly, right? Germany has to, it's in the shadow of World War II and the Holocaust. South Africa says so explicitly, confronting our history of injustice. India is committed to social justice. The US, not so much, right? And in many ways, I wonder, just is that part unique or particular racial history in the United States? Is that an obstacle to a horizontal effect? Is it a reason why we might perhaps see the US Constitution as more liberal than it actually is, right? So are there those Republican resources in American constitutionalism? There's the strong argument from people like Peter Shane that it's actually not as individualistic and liberal as the American founding. So what is, and maybe just using the US example as the point of jumping off, what role does that racial history play in the perpetuation of the vertical framework or the obstacles to the horizontal effect framework?
Well, that's a great question. And I'll try to answer it as concisely as I can. Well, obviously, it was a motivating factor at the outset when the centrist Republicans and the radical Republicans were debating. People were queasy about enforcing racial equality in private spaces early on. In fact, people were just queasy. Some were queasy about the amendments altogether, of course. And so I think, whereas we see that there were certain Republican resources, maybe a sort of Republican mindset early on too, with the fact that the radical Republicans were making that argument, it wasn't widespread enough to actually gain a foothold. I think, is it Justice Harlan in his dissenting opinion in the civil rights cases actually invokes republicanism, I think explicitly. And so it's there, but yeah, not strongly enough for it to have a significant impact at that juncture. I think what we see in looking at the arc of US constitutionalism is a kind of tension. There's a cementing of the vertical model of the state action doctrine that happens, but all the while, in cases like Shelley, you see Shelley versus Kramer, a tension with the court trying to get past it. And it does in some ways, what I've referred to very briefly just as an exception to the vertical model, like the public function exception. Oftentimes those are used in cases dealing with race in an effort to get around the very strict vertical model in this particular area. So all of that said, I think in general, it would be an oversimplification to say the United States was only liberal in its founding. I think there is a clear history of republicanism. It's just a matter of whether that history, that tradition was leveraged on this particular issue. I think we see it in some of the tensions that I've talked about, but in the end, we still have the vertical model. And then with respect to the other countries you mentioned, there's so much to talk about there. But I will say this issue of race and ethnic equality was informative to India as it adopted its horizontal model, its directive principles of state policy too. So it's definitely underlying its whole constitutional project. Germany is a little more complicated, even though World War II was definitely very present in making its basic law. It hasn't, the particular question of equality has only come up in its horizontal model because of the European Union putting pressure on the German system. So we can talk more about that. I don't want to go on, but I'm looking forward to other questions and follow-ups on this one.
We're starting to get a lot of those questions. So
Okay.
I'll again state, if we do have any student questions, they're going to jump the line. At this point, though, the line is non-students. And those that I have are Woody Kozad, Jay Dow, and Bill Thompson. So we're going to go in that order. As Woody, would you like to ask your question?
Yes, I would. Yes, I would. And it's not the one I sent you.
Okay.
Okay, well.
My question is, I've not read the case in which Douglas writes I think, a concurring opinion, but the last phrase in it is something like which the state cannot enforce.
Right.
Is he not actually trying to make a vertical decision? I can have a segregated coffee shop, but the state of Louisiana, when you sit in my coffee shop, you're African-American, I tell you to leave, I can't avail myself of the state to enforce my right to kick you out.
That's a great observation. And in fact, you're right. So in a way, this case, or I should say Douglas's logic in this case, follows more closely the logic in Shelley v. Kramer, where he wants to say, you can do what you want, but the state can't enforce it. And but he puts emphasis too on the fact that these places have a sort of salience or special meaning for society as a whole. So even if he wasn't looking to opt for a strict horizontal model, it's still maybe like a horizontal light or some version of the vertical model. It's certainly not, his concurring opinion doesn't necessarily accept the conventional wisdom of what the vertical model is either. Shelley v. Kramer, as just using that as an example, was a sort of high watermark. We don't see any other cases employing that kind of logic in the US. But yeah, your point is well taken. This isn't he's not exactly advocating for a horizontal model per se.
Great, thanks. Let's go now to Jay Dow.
I'm going to ask a question about Commerce Clause, and I just saw Woody's question there, so Woody may get a twofer on this one because my question is in the same vein. You described the Commerce Clause as sort of an awkward device for dealing with these sorts of questions, and I guess I want you to elaborate on that just a little bit, because to me it seems like an immensely successful device and has the advantage of being quite streamlined. When Congress has legislated under the Commerce Clause, they've clearly been forced to delineate its applicability and non-applicability. And then in cases like Morrison and Lopez, where Commerce gets a little too anxious, there's a clear foundation for the courts to go back and say, you've overreached. So I'm just curious, for these kinds of discriminatory or rights-based actions, what is the critique of the Commerce Clause?
Great, thank you for that.
And I enjoyed the talk, by the way, immensely.
Thank you very much. I think the simple answer, and you can tell me if this isn't satisfying, is just as a moral matter. If you're talking about equality, racial equality, what exactly does commerce have to do with it on the face of it? And of course, Congress makes the argument, the court makes its argument in Katzenbach and the following court cases. But if you're looking for a constitutional basis for what the Civil Rights Act does, it's not clear to me that commerce makes the most sense as a maybe moral, symbolic matter. Of course, you're right. The Commerce Clause has been employed to many different ends, and we do see the court, well, actually, maybe this is another answer to your question. The very fact that the court has rolled back the Commerce Clause in certain instances, or looked to reground legislation, say in the Sibelius case, the ACA case, in other instances, it's not clear that the court is consistently willing to uphold legislation on this basis. And so by having the Civil Rights Act grounded in something that was more related to, in fact, civil rights, might have given it firmer basis, in theory. Of course, we're talking in hypotheticals now, but I'd want to suggest that.
That's fine to me. One of the things that came to mind when you were talking, though, is the old Antonin Scalia remark about why our rights are protected. And he points out the Soviet Union had a really, really good Bill of Rights.
Right.
And so when I look at other areas of the Constitution that might be applicable to protecting what we would consider to be basic rights, it seems to be one of the foundations. Anyway, I love the talk, and that's a fine answer.
Thank you.
It is a fine answer. I'm going to push it a little bit further and ask you maybe if there is a critique here that you have of maybe equality jurisprudence or the egalitarian project in modern American constitutionalism as with the Commerce Clause as a vehicle, right? So one way to think of it is, would actual horizontal effect make a difference? Because there's one sense in which the vertical, right, they didn't use a rights guarantee. So instead they essentially liberalized this Republican tradition by making it about economic transactions, right? So it's all about workplace, or it's about public accommodations, and that. So does that not close the gap fully, or is that a substitute, kind of like an American constitutional hack to do this other project that you're drawing attention to?
Yeah, no, I think that's right. It's a kind of stopgap. I think the court, and if you look at private correspondences when the court was deciding cases like Louisiana v. Gardner, they really wanted to decide the case on the basis of equality, because it made sense in light of what the case was about. They suggested possibly decoupling the different parts of the 14th Amendment. So the first section versus the fifth section, let Congress do what they want to. This is what we will do as courts. So yeah, I think what you say is right. It's a kind of hack, but it's a hack that I think many people still see as a hack. And so for that, maybe we can call the Civil Rights Act a super statute even still and not worry too much about it. But I think just as a symbolic matter, and seeing how actions taken on the national stage, the Supreme Court is a national seminar, as some have called it, it might have gone some ways to reconceive of this project of equality on that basis.
It's an excellent segue to our next question from Bill Thompson, the invocation of courts. Bill, do you want to ask it?
Sure. Given that you can have horizontal effect through legislation, for example, Title VII, which can be more detailed and clearer, what is the advantage of a horizontal constitutional theory which uses less clear language? And doesn't that enhance the role of non-democratic courts?
That's an excellent question. And honestly, it's these sorts of questions that really motivate me in studying this topic. This would be, as you framed it, this would be an argument in favor of the vertical model, that these are, political questions that we want to be decided deliberatively in legislative bodies by and large. So with that, to answer your actual question, what's the advantage of the horizontal model? I think it would be to acknowledge in those instances how commitments a constitution makes, let's think about South Africa, for example, are in fact transformative. So if a polity comes together and decides simply there is no space for nuance in this area, for South Africa, again, long history of racial inequality, it doesn't seem that there would be, they didn't want much room for difference. Does that make sense? So whereas the advantage of the vertical model is to allow for nuance, to allow legislators to treat different cases differently, what the horizontal model does for constitutional duties is what constitutions do for rights. It entrenches them. So if we want constitutional duties to be entrenched and not subject to legislation, not subject to changes in legislation, then that is when you can imagine constitution makers or courts coming in and saying, we want to adopt this horizontal model. Does that answer your question?
Yeah, it just seems that a horizontal model is less flexible. You can't correct mistakes as quickly.
Right.
And you can't be as fine-tuned as to what you're actually trying to accomplish.
And so that is maybe the pro and the con, in the same way that we have seen, just inherent to constitutionalism, this desire to entrench rights. What the horizontal model brings is this entrenchment of duties. And first, in some countries, they've seen that as a plus, as a reason to adopt it. Sure. And so one other thing to add, just to get into the mechanics of how horizontal effect works. If a right has horizontal effect, say you have a right to property versus a right to housing, as we saw in the motor clip case that I mentioned, the court won't necessarily say this person has a right to housing, therefore this other person is automatically obligated to provide for it. The court always engages in a sort of balancing. So how important is this right to housing in this case versus this right to property? And so, your point still stands. You're subjecting these questions to courts, and so you have to be comfortable with that. But it isn't always the case that one party would come out ahead over the other.
Thanks very much.
Yeah, of course.
We'll now go to a student question from William Kemp.
Would you like me to read it, or?
I would like you to read it.
I'll just do a general synopsis of it. Listening to this, I was just wondering that it seems that there's a substantial amount of jurisprudence now that rests upon the state action doctrine. So I was wondering if you see a viable alternative to shifting the horizontal towards the shifting the vertical towards the horizontal without upsetting that substantial amount of precedent and just causing what seems to me might be chaos for a number of years in the federal judiciary.
Great question. I think that if it was going to happen, it would have happened during the civil rights movement. I think the court had an opportunity if it wanted to take it. I'm not saying that they made the wrong decision, but if they wanted it, that is when they would have. And if you read some of the correspondences alongside what Congress was discussing at any given time then you see it's almost a game of chicken. Like, the court doesn't want to do anything to upset the progress that Congress was making with respect to these issues, and Congress didn't want to overstep and legislate on the basis of equal protection when that might have been overturned in courts. So there was a real desire then. I think now, I don't really see how it would be implemented as a practical matter. Of course, we have a lot of these provisions just coming through legislation. So in effect, a lot of legislation, both at the national and the state level, does what horizontal effect would do. And I see that being how we operate for at least the foreseeable future.
Thanks, William. We'll now go to Justin Dyer. Could you unmute, Justin?
I was muted. Sorry about that. Christina, thank you for that talk. It was very good, very interesting. I was thinking about the state action doctrine in the Winnebago case, and I hope you can help me think clearer about this. And actually, there are several lawyers on the call, and they can help out with this as well.
Oh, good.
The Winnebago case, you have the 14th Amendment says that no state should deny any person the equal protection of the laws or deprive them of their life, liberty, or property without the due process of law. Joshua Duchene is abused by his father. He goes into a coma. The mother then wants to hold the state responsible for that abuse.
Right.
And there's nothing about the case that says that there aren't the existence of private rights and duties. It's just not coming from the US Constitution. But she could sue the father under state law. The problem was the father didn't have any money and he couldn't pay and all of that. But I was thinking about just the general question of private rights and duties under state law as opposed to the national constitution. And if we just widened our lens a little bit and thought about the US constitutional tradition to include all of the state constitutions, is there a more robust tradition of thinking about private rights and private duties at the state level that just looks limited when you think about the national constitution because it has such a limited scope and purpose?
Yeah, that's a great question. And that's exactly right. In fact, one of my next papers I want to write is exactly on this because there isn't much on it. But in fact, the states are not generally subject to the state action doctrine in the same way. And so if California wants to have a right to healthcare and wants to apply that horizontally, they can. I mentioned abortion in my introductory remarks. And in fact, there is a case out of New Jersey, I think in the 1970s, in which a private hospital was held responsible for providing an abortion. They didn't have a choice in that matter. And so the terrain at the state level is very different, and it's worth considering on its own, absolutely.
If anyone else wants to jump in with the question, feel free to do so now. Otherwise, I'm just going to keep going with questions because I have more. And again, this is just an invitation to say more about the bigger project in some of the case studies that you've worked on, and it's maybe an unhelpfully large question, but it's a question that I just want to hear your thoughts on. Given the relevance of human dignity in South Africa, India, right, Germany, and some would say the United States, is dignity a liberal value or a Republican value?
That's a great question. I could see a person casting it in either way. My larger project draws on a concept of solidarity. So horizontal effect tries to impose from the top down a kind of solidarity among citizens where it might not exist. So I think this explains in India, South Africa, for example. And so to the extent that maybe we wanted court enforcement of citizens to recognize each other's dignity, maybe you can put it in that light. Insofar as republicanism, classical republicanism relied on a conception of dignity across the citizenry, sort of equal standing, then to the extent that we might describe horizontal effect as trying to accomplish that, maybe it could serve that end. On the liberal side, I mean, I can easily think of arguments about, say, the pre-political nature of the private sphere and how giving due recognition for the dignity of those of individuals, primarily in that private space, is warranted. So I could see it cutting both ways. It's a good question. I'd have to think more about it.
Christina, as a quick follow-up, in this conversation, what does liberal and Republican mean?
That's a good question.
Thank you. Yes, historians had that question.
Sorry, I should have clarified. So when I say liberal, I mean the classical liberal tradition associated by with such people as, say, John Locke, for example, emphasis on rights, emphasis on private property, separate public and private spheres, limited government. So we speak about liberal constitutionalism, and generally that means, the Constitution is about restraining government. You can also say about empowering government, but the point is that it outlines the contours in which government operates. So that is liberalism. Republicanism, I probably should have said too, I don't mean anything related to the current Republican Party that we talk about in politics, but the classical Republican tradition associated with a vast array of theorists. And in fact, one of my challenges has been to use this term in a way that can account for just how many iterations of this theory there have been. So, you can go all the way back to Aristotle, Cicero, you might think of Rousseau, you can think of contemporary neo-Republicans like Philip Pettit. And I think the way I use the term is simply to refer to this prioritization of duty. You don't really get that in liberal theory. To talk about solidarity among citizens, again, not something you really see in liberal theory too much. And also a conception of a uniform common good. So we're not dividing public and private spheres as much as we are talking about a common project, a common good to which everyone, regardless of their status as a government actor or not, is accountable. So I'm happy to clarify more, but that's generally where I'm coming from with those terms.
Yeah, and I'll just add, Christina's piece, Horizontal Rights, actually has a many-page section outlining in very precise detail, unless it's changed since then, your conception. And I found it really, it's a great review of several centuries of political thought. For that reason, it might still rankle some of our historian friends.
Yes.
And those are interesting conversations that I'm sure you'll continue to have. A follow-on question from that, though, given those definitions of liberalism and republicanism, and I thought of this in connection with obviously the abortion cases, things like Bostock, probably even the social media regulation, would horizontal effect require the kind of position taking that liberalism ostensibly seeks to avoid, right? So if one of the good things about liberalism is that it allows us to all get along, even though we don't agree fundamentally on things, to the extent that horizontal effect socializes constitutional values, right? It encourages compliance with the power of the state. Isn't there a fundamental tension there? Or can that be avoided? I have a final question that we'll go to if no one else jumps in. I don't want to go there quite yet, but it's reaching in that direction. But does it require something that liberalism, as a matter of principle, would reject?
That's a great question. And honestly, I've been thinking about this all semester, so I'm happy to hear from others too, to the extent that my answer may or may not be satisfying. I'm hesitant to say that liberalism doesn't take a position at all. Of course, the whole point was to bracket a certain set of issues that we wouldn't emphasize in public spaces. And so I think the vertical model does try to accomplish that sort of, to create a kind of buffer so that if and when there are differences, we can allow for difference to exist. So one of my old professors at UT, Jay Budziszewski, draws a distinction between declaratory and coercive. So we can say that the vertical model tries to avoid making all of the projects that it commits to as a matter of declaration also coercive, if that makes sense for everybody. The horizontal model, on the other hand, doesn't worry so much about this. If there's a commitment to the Constitution, you're living in that polity. And so there's some sense in which you are accountable to it and living under it. One critique of the vertical model might be that even if you are somehow buffered from the projects of the Constitution, you're still living under a Congress that's accountable to that Constitution. And so indirectly, you may find yourself accountable to it too. But the point is that the horizontal model is much less queasy about that than I would say the vertical model is.
If there aren't further questions, I'll end with my last question, which everything has led up to this. And I'll give you some context, is that every time I teach human dignity, I start with Steven Pinker's wonderfully titled piece, "Dignity is Stupid." And he makes the claim, no liberal society can affirm a substantive conception of human dignity. And in the terms that you're talking about, you may reject that. In the terms that you're talking about, that might track into liberal and Republican. So the question is, as you reach towards which is preferable, do we need to pick one and only one? Can they coexist in I don't want to say a liberal constitutionalism, but a productive constitutionalism, or does one dominate? Does one not permit the existence of the other?
Great question. I think we see many countries trying to strike a balance. And so you mentioned Germany before. Germany has what they call indirect horizontal effect, which basically means constitutional obligations don't come to bear directly on private actors. But that said, sometimes the legislature, parliament in Germany, will be called upon to legislate in particular ways as a constitutional matter to make sure that there's a certain state of affairs in the private sphere that lives up to the Constitution's projects. Does that make sense? A little rambling. So in other words, horizontal effect happens indirectly through legislation in Germany, but the legislation is basically required as a constitutional matter. They're required to take action. So this is a way that you could say some people have tried to strike that balance. It still allows for that deliberative process to happen through legislatures. You're not just jumping to the courts. So that would probably be an example. I think you can also point toward, say, just the hypothetical scenario if the radical Republicans had their way and the first Civil Rights Act had stood up. That would have been a way to still keep the legislatures in the picture to hopefully accommodate different issues, different scenarios that might come up in a way that are more difficult to deal with when you're just talking about rights against each other.
Is there anybody else want to jump in as a final?
Yes, this is Woody Kozat, and I don't want you to even try to answer this.
Okay.
Just think about it as you go forward with what you're working on. Underlying this is my belief that the Civil Rights Act in the South in particular has been an incredible success. And so I asked myself the question, if we had tried to achieve, dignity, whatever you want to call it, for African Americans in the South through this horizontal model, practically, what happens politically? What do you do to assert your right? Against whom do you assert it? How do they react to your assertion of it when it comes in this fashion? And what does that look like when it's all said and done? Because what's happened, in my view, looks a lot better than people describe it today. In fact, the success is more than anybody should have expected to happen in 2 generations. Mm-hmm. And if I'm right about that, or even close to right, what would a horizontal system have achieved? And how would it have achieved it? And what would the reaction have been, and so on? That's
a great question. And it is a big one. I'll just say that this is in part why I suggest that we need to keep an eye toward each country's history, the current conditions in a particular place, in making these kinds of decisions. But I don't want to dodge the question, because I did propose that something like the horizontal model might have been useful here. And I guess it's just hard to think through. If we begin with the possibility that maybe the radical Republicans had achieved what they wanted to in the first Civil Rights Act, I mean, you can imagine things still happening incrementally, possibly. You have this law on the books, but maybe the implementation, the rollout, allows for these new commitments to be internalized. It's a good point, and it's a good question. It's hard to think through the hypotheticals, but I'll definitely keep it in mind.
Woody, one possible answer to that might be, and Christina, you might think about this too, would it have not just looked like the 1875 Civil Rights Act?
Right, exactly.
Where you get the Civil Rights Act, which you get it 90 years before.
Earlier, right, exactly.
And you enforce it in the same way that the act would have enforced it, which would be penalties to business owners who didn't open to everyone, enforced by the national government.
Right.
But just not through the Commerce Clause. So what you gain is you have a much more restrained Commerce Clause jurisprudence.
Right.
I think at the expense of what that means. So I don't know that much about remember that much about the old one, but so that was the one that they could really only enforce by having federal troops down there, right?
Yeah, and that might be the question. So what's
which were then removed, like
the actual practical way to enforce? But the old one said you can't discriminate on the basis of race, color, previous condition of servitude in public inns,
right,
as one example. And the court strikes that down, and then in 1964 they hear the case, which is exactly the same as 1875. Can you discriminate in your hotel in Atlanta? And the court says no, but they uphold it under the Commerce Clause, and so it still maintains that vertical model.
Mm-hmm.
And actually, as a side note, I was just teaching about this. The owner of the Heart of Atlanta Motel argued his own case in oral arguments at the Supreme Court.
Oh, really? Is that right?
and you can listen to it on Oyez.
All right, I'll do that.
Yeah.
I'd be remiss if I didn't also add the federalism dimension to this.
Yes.
I don't know the answer to it, but Woody's question kind of inspired it, is in a federal system where there are effectively, enclaves of white rule in the South into the early 70s, is there even a prospect for a horizontal effect, right? That it seems to me that something like the vertical model holds out the possibility of some legal redress, even if it's just parties to a case, public right, attenuated maybe through vehicles of commerce. But I wonder if there is maybe a different dimension to this given governmental structure, given federalism. You don't have to say anything about that.
No, it's a great point though.
If there isn't anything else, I think this is as good a time as any to call an end, not only to this, but to our long weeks and launch into the weekend. But Jeff, do you want to say
Connor,
something?
could I thank you for doing this? I just wanted to make sure everyone knows there is another one of these next week. where Dave Dunkley of the Black Studies Department will talk about something completely different, Anglican evangelism and slavery in 18th century Jamaica.
Yes. So show up. Christina, you're always invited to come back.
You're always invited. The world's invited.
Yeah.
Exactly.
Wonderful.
Yeah, but thank you so much for sharing this really amazing and exciting project. We look forward to seeing where it goes. Hopefully the next chapter at some point is the book, which will bring you back hopefully to campus to talk about.
Great. Thank you so much. It's been a pleasure.